Okay, our next case is case number 224C0483, Michael Magnus versus Two Men in a Truck. Mr. Magnus, I think I've seen you up here.
Yeah, I'm here.
There you are. Good morning. Do I have anybody from Two Men in a Truck?
Yes, Your Honor.
What's your name?
Michael.
Okay, Michael. Better give me your last name.
Poor, P as in Peter, O-E-R.
Okay. All right, here's what I understand from looking at the file. Mr. Magnus hired you guys to move his stuff. In the course of the move, a television was damaged. There was some correspondence back and forth and a kind of a interesting picture of the damage to the television. Plaintiff claims that the TV was damaged in transit or in the move. He's asked to be compensated for the damage to his television. Looking at the contract, it appears to me that both sides agreed that Mr. Magnus was going to be covered by a supplemental insurance policy, and he has made a claim. There's been a lot of correspondence back and forth. Frankly, from the defendant's standpoint, I don't want to speak for you, but as I read the correspondence back and forth, you really haven't denied that there was any damage. You just haven't gotten around to getting the insurance for it. So based on that, let's start with Mr. Magnus. And Mr. Magnus, you and Mr. Poor, raise your right hands for me, please. You both solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, yes. Mr. Magnus, you're on. Did I misstate anything when I summarized the case?
No, you didn't misstate anything. There was a move. The TV got broken. I had the insurance for it. You know, the Mr. Poor and his side first wrote back saying that they plugged the TV in when they moved it and it worked. That wasn't true. Then his next story was they never moved the TV. That was the next story that came through on the emails, that they didn't move it. That's not true either. So I actually have a list. Two Men in a Truck moved me twice, moved me in July and then in October. And in the list of items, they have listed the TV, to move the TV, and they even charged me for a rental box to move the TV. So I'm just looking to get the claim on the insurance and get the TV replaced.
Okay. Mr. Poor, let me hear from you.
So what I was told by Mr. Magnus that, yep, we ended up moving TVs. So I looked at the estimate, and on the estimate, it did have TVs on there. But I talked to the crew that did the actual move, and all of them that were on the move told me that they did not move any TVs. They did not take any TVs, put them on our truck.
I understood there were two TVs moved.
Yep, there were two TVs moved.
So my guys, they told me that they did not move any TVs. They did not put any TVs on our truck. And
well, I have to tell you, I find that hard to believe. When you're moving somebody from one residence to another, most people have TVs, and that would be part of the move. And it is listed as something that was going to be moved. So I don't know what your guys were seeing, or whether they were totally upright and accurate in telling you they didn't move any TVs. So I'm a little skeptical about that report. So let me just ask you this. Let's assume, for purposes of our discussion today, that the TV was moved and that it was damaged. Who makes the request to the insurance company?
We end up looking at things, and it's actually not an insurance company. It's a valuation. So the customer is paying a certain amount, valuing their items. He
paid $60 for the policy. And I understand that. So basically what you're telling me is you're self-insured, and if there's damage, you guys pay it. Is that right?
Correct.
Okay. All right. Do you want to tell me anything else?
So before our guys even left, they told me that the TVs, they saw the TVs turned on in the customer's house.
It's kind of interesting that they didn't move any TVs, but they plugged the TVs in to look at it. Don't you find that a little hard to believe?
At times, yes, but there are customers that decide to move their own TVs on their own.
Yeah, I'm sure there are. But if somebody told you that if one of your guys told you, and by the way, I have no prejudice against you guys. let me disclose that I used to work for the state's largest law firm, and we used you guys to move our furniture all the time. So I'm familiar with your company, and know that you pretty much stand by your guarantees. So having said that, I find it, I don't find it credible that on the one hand, they can say they turned on the TV to make sure it worked. And on the other hand, they can say they didn't move any TVs. So here's what I'm going to do. Mr. Magnus, I'm not going to have you provide me anything further because I'm ready to rule on this. I'm going to find in favor of the plaintiff in this matter. The amount claimed and I think supported is $1,699.99. Is that right, Mr. Magnus?
Last time you just added the cost of the claim. It was a little bit more. What was it, $50 or something?
Okay, let me just ask you, where did you get that number from?
No, I got that number from the cost of the TV the last time we met.
Okay,
Jeff.
that's fine. That's all I needed to know.
Yeah.
All right, you have costs of $57, and those will be included with the award. And you will both get a copy of the judgment. Let me tell you both, not necessarily that you're going to be interested, Mr. Magnus, but Michael, Mr. Poor, if you believe my ruling is incorrect, you have 7 days to appeal it. Not going to hurt my feelings. It's a simple process. All I have to do is call the clerk's office and they'll walk you through it. Okay?
Okay. I do have the driver that was on the move here sitting next to me. Is he able to say anything?
Well, he can say anything he wants, but I assume what you told me, he told you, correct?
He was one of them, yes.
Yeah, okay. Well, then I don't see where he has anything to add other than what you've told me.
Because I do have a picture of the TV that Mr. Magnus is saying that we damaged, and there is a ladder standing right behind the picture of or in the picture. So how could the customer possibly hang it up on the wall and with the ladder that's there and possibly broke it himself?
Yeah. Okay. Well, that doesn't change my decision. So my decision is that the plaintiff is awarded $1,699.99 for replacement costs of the broken TV plus $57 in costs. You'll get a judgment to that effect. And as I say, 7 days to appeal it if you want to do that. All right. Thank you both for showing up this morning. Appreciate it.
Thank you, Judge.
Yep. Our next matter is Isam Dia versus Magdi Isa. I understand that this was an issue where plaintiff claims she lent the defendant $1,400 with the understanding that it was to be repaid on a short-term basis. My understanding, since I don't have a written contract, is that this was an oral agreement between the two parties. It appears that the plaintiff has made several requests for repayment and has not been repaid. Ms. Dia, what do you think? Does that about sum it up?
Correct. And I can give some more backstory if that helps.
But I'm going to let you do that. Okay, Ms. Dia, give me the background.
Sure. The defendant and I had a friendship, one in which I obviously built some trust with him. So in the fall of last year, we were at his house. He said he reached his limit on his gambling app and asked if I would download it to my phone and let him play. I did, and I gave him the login information. Initially, I uploaded $400, which he paid me back for immediately. That same night.
That's not part of this claim, though,
no.
Right? Okay, go ahead.
That same night, the app had a promo that would match the amount he uploaded to the balance. So he asked that I add $1,400, clearly saying he'd pay me back, which I did. About a week goes by. I didn't mention the money to him. I figured he had no reason not to pay me back. He seemingly was well off, so I figured it would happen when we saw each other next.
Okay, so how many times have you asked him for payment since the time you lent him the money?
Several.
What does several mean? How many?
Oh goodness.
Give me your
more
best
than 10.
More
I would
than-
have to go through.
Okay, all right, never mind. That's what I wanted to know.
Yeah.
All
So I noticed he started to ignore me, which was fine as long as he paid me back, but it became clear he had no intention I'll give you my money back. After a few weeks of me asking him, he eventually blocked my number. During mediation, he agreed to pay me back, gave me a check that bounced. Also during mediation, he denied I ever gave him login information, but I have text messages of me sending it to him that night. I also have text messages, several of them, of him acknowledging that he owes me money.
Okay.
And one text message of him even telling me the amount that he owes me.
All
I had
right.
text messages of him basically telling me if I took him to court, no one would believe me because I uploaded the money to my own account. I also have the IP addresses of the logins to the app, which indicate that it was on the phone, same one he had at that time on
Okay,
Wi-Fi in the area where he
I'm
lives.
good with all of that. I understand that.
Also happy to share screen, Your Honor, of all the
Yeah,
text
no, I
messages.
understand. I think I have this one. You lent Mr. East $1,400. He's turned off his phone with regard to you. You had an oral understanding that he was to pay you back. I don't know that you were tremendously thoughtful in terms of lending him money to gamble with, but it was apparently nice of you to do for a friend. So, Mr. Issa, why don't you owe
How's it going?
the plaintiff $1,400?
So I did agree on mediation to pay her, and
Have you paid her?
the reason
Have
the
you paid
reason
her?
the check bounced it.
Wait,
So
let
the
me ask.
reason the check.
Hey, Mr. Issa, let me
Yeah,
ask you a question.
I gave her a check, and the check was dated for that Friday. I gave her, and I have Huntington Bank, and I have Positive Pay. So when I inputted the check into Positive Pay, I had it dated for that Friday, and for the amount, and whatever bank she took it, tried to push it through a Thursday, the day before, and that's why it got rejected.
Okay, here's what we're going to do. You acknowledge that you owe the plaintiff $1,400.
Your Honor, before I'm only paying the plaintiff the $1,400 not to deal with a headache. I have a bunch of text messages, and that day on my pool table, I had over $100,000 of cash sitting on there. That $5,000 of it was missing when she left my house. But I'm not worried about it. Like she said,
Well,
money's
that's
not an
good
issue
since you
for
have
me.
no claim in this case for that, and it's totally irrelevant to what I'm deciding today.
Yeah,
So,
yeah, no. I was gonna tell you right in the beginning. I can Zell her right now if you put us in a private room, and she can get the money right now.
well, she is going to get the money right now. You're ordered to provide Ms. Dia with a cashier's check for $1,400 and the cost for having to try and collect this, which are, and I will tell you quickly, $62. So you owe the.
Your Honor, I have proof
Hey,
that the check
listen,
was rejected.
did you remember what I said about one person talking at a time, and when I'm talking, that's the person who's talking?
Yes, sir.
Okay, quit interrupting me. I'll give you a chance to talk, but we can only do this with one person talking at a time.
Yes, sir.
All right. Now, my ruling is that the plaintiff is entitled to $1,462. It's to be paid by cashier's check within 5 days. Now, did you want to say something else? Apparently, you're
Yes,
flush
Your Honor.
with money.
Yes, Your Honor. I have proof that the check was rejected due to
I
the
don't
fact
care.
that whatever
I
bank
don't care. The check was rejected. That's absolutely irrelevant to what we're doing here today. The plaintiff has not been paid the $1,400. I don't care whose fault it was. You owe her $1,462. That will be paid by cashier's check within 5 days. No more issues. Okay? Do you understand my ruling?
Yes, sir.
Okay, good. Get to the bank and get a cashier's check for $1,462 made payable to Islam Dia.
No
Understood?
problem.
Okay,
Thank you, Your
Honor.
you'll get a written judgment to that effect. Thank you both for showing up today.
Thank you.
Yep.
You're welcome. All right, case number 221 C2556. Ursula McClare versus Wall Street Towing, David Single and Joseph McCants. I want to start with the plaintiff. Ms. McClare, are you here? Take your mic, take your thing off mute. Okay, there you go. All right, Ms. McClare, right?
Yes,
Excellent. Is there a representative of Wall Street Towing present?
My name is Fatty Salomon. I represent Wall Street Towing.
Okay. Give me your spell your last name for me.
S is in Sam, A is in Alpha, L is in Lima, A is in Alpha, M is in Mary, E is in Edward, Y is in Yellow.
Okay, I got FALM. Don't give me as you know,
I'm
just
sorry.
give me the letters. All right, let's see. What about Mr. Single? Are you present? All right, Mr. Single is not here. Joseph McCants, are you present? Mr. McCants is not present. Mr. Conti, I see you out there. I've been informed that you're potentially a witness. Who are you a witness for?
Your Honor, I am a witness for Wall Street Towing. Your
Okay.
Honor, I just
All right,
want you
that's
to-
all I need to know at this point. I'll get to you. Okay, here's what I understand about this. You claim that your car was either improperly towed or that the charges were unreasonable. I think I saw the number, although it was kind of smushed on the form, of $1,326. Is that what you're claiming?
I believe.
Yes.
Okay, good.
Your Honor, can I let you know that my husband?
No, let me just summarize it first, and you know.
Okay,
I just want to be sure that's what your claim is. I'm going to let you tell me how you got to that number and the basis for your claim. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Okay, Ms. McClare, I want to hear from you first. Tell me about this.
I want my husband to talk because he was more over the car than I was. The car just was in my name.
Okay, you're okay. All right, I'll accept that.
Okay.
Is it Mr. McClare?
No, Mr. Smith, Your Honor.
Mr. Smith. All right, hang on. All right, Mr. Smith, tell me what happened.
Your Honor, first of all, I do lawn service for that building and for Mr. David's house. So I had an agreement to park my truck there and my car there. My car was parked in the inside because it was a Jaguars.
Tell me where this is.
This is the building is on Mansfield. I want to say it's on Mansfield, and it was called Paint Mix or Mixed Paint at the time because I've been
Okay.
cutting the
It's a commercial
building. Yeah.
All right.
And I have been
And
cutting
you
it.
have an assigned spot.
Yeah, I had two spots, but I'm
spots.
just dealing with the Jag right now because I couldn't afford to put the money up to do the truck. It was one or the
Okay.
other.
All right.
So I was cutting the lawn and I noticed the truck was gone. I said, "Oh, they cleaned up around here. It looks pretty nice." So as I'm continuing to mow the lawn, I'm like, "Wait a minute. If that truck is gone, my Jag is probably gone." So I got a hold of the guy, Joseph, and I said, "Hey man, what's going on? Where's that truck? Did you just move it somewhere?" And he's like, "Oh man, they came and took it." I said, "So didn't you think you should call me or I should have got some type of warning? Considering I have a contract with you that I'm paying you to keep these cars here?" And I said, "So is the Jaguar there?" He's like, "No, they went in and took the Jaguar too." And I'm like, "Well, when was somebody going to tell me?" Then I got a letter after they took it. I got a letter after the cars was taken on the 12th or 10th, somewhere around there. And I'm like, "Well, how can I get a letter?" And I never got a warning because I could have went and got my cars. I could have got everything out of there. I never received a warning from the city. I never seen a warning from the towing company. I never seen a warning from the owner of the building. The only warning I knew was when I noticed the car was gone, and he was like, "Oh, the lawyer's going to work on it. They're going to get it back."
Mr. Smith,
Then I get a
let me
letter.
ask you this. How long had you been parking your vehicles there, either the truck or the Jaguar?
The contract says 2018, so I'm guessing it's right around there. The contract I'm looking at in my phone.
Right,
and
so you have a pattern and practice of being allowed to park there
Yes.
for almost 4 years.
Yes.
Okay, all right. Okay, let's move on to Wall Street and find out what they have to say. Mr. Conti, you hang in there. I'll get to you after I hear directly from Wall Street. Go ahead, Mr. Salmi.
We were court ordered to remove the property.
What was the basis of the order? Was it an abandoned vehicle?
It was,
They have to give you a reason. It's either illegally parked or abandoned or parked in a.
I received a letter from Guy Conti saying the following. I am lawfully appointed special fiduciary dealing with 612 South Mansfield, Ypsilanti 48197. Please see the relevant orders of the Washtenaw County Circuit Court, which are attached. I have the authority over the real property and all personal property at the address. You are authorized to enter the property and remove any and all personal property with VINs or appropriate serial numbers, as I have determined them to be abandoned.
Okay, who's this from?
Guy Conti.
Say it again.
Guy Conti.
Is that a corporation?
No, that's the attorney.
That's the guy on.
Okay, all right.
So he basically told us to go to this property and take anything that had VINs or serial numbers to help remove it. Apparently, and I'm guessing apparently that the property had been sold and that he had the fiduciary responsibility to clean up the property.
Well, let's find out from him directly. Okay, Mr. Conti, you're on.
Good morning, Your Honor. Good morning, everyone else. Your Honor, I am the special fiduciary in case number 19-611-CZ, 19-611-CZ. Judge Connors presiding. I have an order dated 2/3/2021, which I provided to Mr. Salami, that gives me authority over real property at 612 South Mansfield, as well as
There was some
all
background
personal
noise.
property.
You got an order from Tim Connors that gives you the authority to do what?
The authority to take control of and sell all property, real and personal, that is at 612 South Mansfield, Your Honor. Realizing that we had cars that were that had VIN numbers, and given that I had to sell the property, I had the cars removed after I had given warning to Mr. Single, the owner of the previous owner of the property, because it's now been sold. I had given him notice in writing that any automobiles that were not removed, any property that were not removed, were subject to being removed, disposed of, or otherwise sold.
Did you have an understanding of any existing contractual agreements? For example, allowing Mr. Smith to park there since 2018?
I did not, Your Honor.
One person at a time.
I
Okay.
did not, Your Honor. In fact, Mr. Smith has testified that his agreement was with Mr. Single's son, Mr. McCants, who was not an owner of the property. Mr. Single has, I understand this is hearsay, Your Honor, but I will let you know, Mr. Single.
Hey, we're pretty informal here today. Go ahead.
I know, Your Honor. Mr. Single informed me that he was not aware of the arrangements that Mr. McCants, his son, had made to lease space for the automobiles, which is why he did not respond to my warnings to have them removed.
Okay, hang on for 1 second. Mr. Smith,
Yes,
did you pay for these parking spaces?
yes.
How
I
much?
have a contract for $200 a month.
Okay, I believe that. I just want to know how much you paid.
$200 a month.
Okay.
Do you have receipts?
All right, Mr. Conti, go ahead.
Your Honor, we tried to have the property removed for well over 6 months. Nothing.
Did you ever
was removed.
contact Mr. Smith?
I had no idea Mr. Smith existed, Your Honor. He did not have a contract with Mr. Single or the business that was there. He had a contract with Mr. Single's son, who evidently had never told Mr. Single. So nobody knew anything about this. All we knew is this was not the only car, Your Honor. There were about half a dozen to almost a dozen serial numbered or VINed vehicles on the property. And given the order that I have, which I can present to the court, which says the special fiduciary shall have full authority and respect to all aspects.
I understand what those orders look like. I practiced for 45 years. So
yes, Your Honor.
I understand
I'm not trying
that.
to be patronizing. I just want the court to have the facts.
Yeah, I got it. All right. So you have permission from Judge Connors to clean up the property, take possession of any property that's on the location that's specified, I assume, in the order. and you did so, you gave notice to the former owner, Mr. Single, who you claimed did not sign the contract, but that his son did. Did his son have any position with the actual entity that owned the property?
Your Honor, the entity did not own the property. Mr. Single owned the property himself personally.
Okay, and do you know if Mr. McCants operated with any authority from Mr. Single regarding this property?
Your Honor, I can't draw a legal conclusion. What I can tell you is that Mr. Single said he was not aware of the cars being
Okay,
leased.
I understand that, and I believe you. But
Yeah, no, I know.
That's a different. Yeah, it's a different question that I'm asking.
I know. I said I can't draw that conclusion, that legal conclusion. I don't know, Your Honor.
Okay, that's fine. That's fine. All right. So there are two things you need that you can possibly claim here, Mr. Smith. One is that the car was improperly towed or impounded, and two, that the charge for that was excessive. All right.
Yes.
So what are you claiming here? Are you claiming that it shouldn't have been towed, number one, and number two, that the charge is excessive? Both things here?
Yes, yes, Your Honor. I would just like to be reimbursed for my car. That's
Okay.
what I would like to be reimbursed because I was not notified.
All right. Where does the 1326 number come from?
That comes from, they said they had to do special stuff to get the car out because it's a Jaguar, so they had to put it on dollies, turn it, do all that. I don't know. When I got there, they said the storage fee and the tow fee, they told me that's what it was.
Okay.
And I couldn't pay for the other car I had. I had to make a decision, and my Jaguar is more important than the little work truck. So
Okay,
I got the Jaguar.
Did you pay that amount? Do you have the Jaguar back?
Yes, I have the Jaguar back, and I paid that amount.
Okay, very good. Okay, did the defendants want to say anything else? Because I think I have a solution here. Mr. Conti, anything else?
No, Your Honor.
Okay, thank you for your forthright rendition of the facts. I appreciate that. Mr. Salome, anything further?
I would just like to say that basically we got court ordered to remove the property. We did it. We did exactly what the court order said. And the charges are based on the work that was required to remove the vehicle from where it was stationed.
Okay. Just give me a minute here because I want to go back and look at some documents. I'll be right back with you. Mr. Smith,
Yes,
who'd you pay the money to? The $200 a month?
I paid it to Joseph. Like I said, I've been cutting their lawn for,
No, give me the last name. Who?
I think it's Singleton. He got it different than his dad. His dad is Singleton. He's, what is Joe's last name? It's on the paperwork. Joseph is.
I just want to know who you paid your money to. Did you pay it to McCants
Joseph,
or Single or both?
I paid it to Mr. McCant, who is Mr. Singleton's son. And
Okay.
to go on further, what that guy was saying, Mr. Singleton's son, Joe, started managing the business when Mr. Singleton started getting sick. He started doing everything. So all I was aware of is he had the keys to the building. I didn't see him and his dad at that building.
Okay, so he had apparent authority with regard
Yeah.
to representing the property.
Yeah.
Okay. All right.
Yes. Sorry.
Well, I'll tell you what. I don't think there was an improper towing here by defendant Wall Street because they were directed by Mr. Conti, who had authority to clean up the property. So I'm going to find that I'm going to dismiss Wall Street.
Okay.
But, your claim really is against McCants and Single.
Okay.
And you named them as defendants in this case, but I can't tell if they were served and if they're aware of today's hearing. Do you know? Joseph
knew. I called him. I asked him, I said, well, what do you want to do? Because everybody told me to call their other lawyer and see if they want to rectify it.
Is Joseph, use last names if you would. Is Joseph McCants?
McCant.
Yeah, okay, go ahead.
And I tried to get a hold of the lawyer that was handling, his name is Jeffrey Charver. He was handling something to do with the selling with Mr. Davis.
Is Single still alive?
Yes, he is.
Okay, all right.
And I was trying to get a hold of their lawyer that they said was going to take everything, named Jeffrey Thrapp. He was supposed to be reimbursing people or helping people figuring out.
Well, here's
And he kept,
what I'm going to do. I can't tell either way. I understand you tell me you've notified them of today's hearing and whatnot. That's not exactly proper service, but it does inform them of today's hearing. And if they had something to say, they should have been here. What I'm going to do is I'm going to enter a default against those two entities. Those two persons, which means you win with regard to the amount you're claiming as to those two. But I'm going to direct the court to serve that judgment on those two, and they will have 7 days to appeal my ruling because I'm not completely satisfied that they received notice of this hearing today.
Understand.
Okay? So all they would have to do is come to the court and say, hey, I didn't know you guys were having a hearing. I want to set the judgment aside. Easy enough to do, and I'll grant that, or Magistrate Fink will grant that. But Wall Street's going to be out.
Okay.
Because they had authority to do what they needed to do for Mr. Conti, and Mr. Conti's got permission from Judge Connors to do what he did.
Okay.
Question is, you in my mind have established at least a course of dealing and a reasonable expectation based on your payments and the period of time that you've had those spots to establish at least a constructive contract with Single and McCants. So
yeah,
we're gonna find in your favor, but be prepared when they get the notice that they may try and come in and set it aside, in which case I will do that and we'll have a full hearing and you can tell me exactly what you told me again, which is pretty persuasive. I'll tell you that. Okay. All right. But here's the thing. We need to know how to get in touch with these guys. Do you have an address for Single and for McCants?
I have a phone number for Joseph, and I don't have their address. I cut the lawn for him. I just know he's off Washington. I just don't know the address by heart. I just know the house.
Okay, so when you make a check payable to McCants, it's just his name. It's not. Where did you send it?
He would call me. He would call me and be like, "Hey, can you meet me up here?" And I would give him cash, and he would say, "Okay." And
so you didn't send it to an address for him.
Nope. He would meet me.
Okay. Well, hang on for a second.
But I do have a phone number.
Okay, we're going to get that from you, but hang on for 1 second.
I can also give you that other lawyer number that's supposed to be representing Mr. Singleton if you would like that.
Mr. Smith.
Yes.
And by the way, Mr. Salome, you can get off. You're done.
Thank you. I appreciate that.
Yeah. I'm going to enter a dismissal with regard to Wall Street, and you'll get a copy of that. Okay.
All right. I appreciate it, sir.
All right. Thanks for showing up today.
Absolutely.
Mr. Smith, I'm going to put the onus on you, since you've had dealing with these guys, of telling the court what the address is for Single and for McCants, because there's nothing we can do to locate these guys. You've got a telephone number. You can use the telephone number, through a reverse thing on your computer to find out what the address is for that number. And as for Single, I'm just giving you my thoughts here. There may be an address at the building that he used to be at, or there may be a forwarding address. But you've got to win right now. But the win is only so good as I know where these guys are, so I can send them a judgment, because you have to be able to collect on that. I can't collect on it if we don't know where these guys are.
Okay.
So I'm putting the onus on you to send the court the addresses of both of those guys.
Hold on, Your Honor. What's your dad's address, Joe? Because I got to send notice to y'all for court. What's your dad's address? Washington, Michigan. Washington
Avenue, Ypsilanti, Michigan.
Yep. Washington Avenue, Ypsilanti, Michigan.
What's his zip?
48197. Also, they got to send a notice to your address, so I need your address so you can eject this if you want.
Are you talking to Mr. McCants?
Yes, I'm talking to Mr. McCant right now.
Okay, let's get his address right now.
43, you said? Lester Avenue.
Spell the name of the street.
Can you spell the name of the street?
Lester.
Lester. Lester.
Okay, and where is that?
And that's Ypsilanti Avenue. And it's the avenue and it's the
Okay,
Ypsilanti.
Lester Avenue, is that Ypsilanti?
Yes,
Okay, and what's the zip?
48198.
Okay,
Perfect, got it.
excellent. We have that. We'll be
All
sure
right.
that,
Thank you, Joe. I'll call you back in a minute. Judge talking to me.
yeah, we'll be sure that the notices are sent to both of those individuals, because I'm gonna find in your favor against those two. Okay?
All right. Well, thank you, Your Honor. And you see,
Oh,
I have a
you're welcome.
casual relationship with them because he answered the phone and gave me
Yeah.
his information.
Yeah, that's pretty good. Okay, thank you.
All right.
We'll take care of our end, and then if they don't appeal, you'll have a judgment against both of those individuals, and you can proceed to collect. Okay?
All right. Thank you.
All right. Thank you. Take care.
Hey, I don't know how to hang up. I don't know how to hang up. Would you think I'm going to your phone?